Is there a way under Texas law to challenge the validity of a marriage because one of the parties to the marriage did not have sufficient mental capacity to understand the nature and consequences of the marriage? The answer is yes. Texas law does provide a method. And you see this come up in situations where family members are concerned that maybe the marriage was based on someone trying to take advantage of someone who is lacking in physical and mental capacity to engage in a marriage and then take advantage of them financially. You often see family members raise this issue of concern. So there is a way to challenge it. First, the Texas Family Code provides that the party to the marriage or their next friend or their guardian can bring a legal challenge to the marriage, and then if they can prove that the person that entered into the marriage lacked the mental capacity to understand the nature of the marriage, and that if they subsequently did obtain mental capacity, that they did not cohabitate with the other person, then the marriage can be annulled, essentially declared void. Now, after a person dies, there is a provision in the Texas Estates Code. And what that says is you can annul a marriage on basically the similar grounds. The key provision there, though, is it has to be brought within 3 years of the date of marriage. So in that case, if you have a situation where somebody who's in very poor physical and mental health gets married, dies a few months later, and then you have the widow or widower trying to claim, half or more of the estate, you have a situation where the family can come in and then contest it within that relatively short time period to show that the marriage essentially should have never taken place and should not be legally recognized.